Thank you so much for coming. We had a brief segment of time where we didn't meet, but I want to give you all a pat on the back because a lot of the decisions that are made at the local level have to do with those who are in office. And I know all of you out there were pounding the pavement, and putting signs out and doing all sorts of stuff. So that's another way to participate in government. So round of applause to yourselves. Great job. Yes, and we're so lucky to have Councilwoman Brenner here with us today. Very excited that you're continuing your participation and learning, because I know that the process of becoming a council member is a hard one, and now you've jumped into the deep end. So we will throw you life preservers as needed. Let us know. So today we are going to talk about CEQA, but just a brief recap of August. We had Laura Stetson here from MIG, and she was a consultant on numerous general plans. She's been through outreach processes, has been engaged in community activism as well as the CEQA process. And so we have most of our presentations recorded, all the PowerPoints, the notes, the handouts on the SPON website, and we will today as well. But in that particular workshop, she focused on making sure that we understood the requirements for a general plan, the elements that are within it, things like housing and transportation, public safety, as well as things that are important like data-driven process, so that we're not just getting information, we're actually using correct baselines and we're updating those baselines. And I think ultimately, I'm gonna pause here for a moment because the city has just launched into this process. And so everything that we've been learning about is now gonna start happening. And so, you know, we've been training our little army and you're almost ready to go into battle, if you will. So part of that process that Jim had mentioned was tying into CEQA. So the general plan gets revised. It's probably going to be a 3-year process where there's community outreach, as well as the development of the general plan, and then an environmental impact report. So EIR, as you've probably heard before, and Jim I know has mentioned it's included on the watch list page, basically encompasses what the impacts are to the project. And Kevin's going to give us an overview of the law that requires that, the California Environmental Quality Act. Kevin and I go way back, probably 12 or 13 years by now. The Planning and Conservation League is the organization up in Sacramento that actually wrote that law. And he has been sitting on that board for how many years now? Probably 30 years, all right, but he's only 40, so so he looks fantastic and he's a genius. I have actually had the pleasure of working with him on multiple projects now, and he's in the process at kind of the statewide level considering what revamps might happen to CEQA that are kind of global changes, because a lot's changed since the 50 years ago when this law was actually passed. So at this point, I think I'm going to stop and let you jump into your handouts. We have packets for everybody because there's a lot of detail that goes into this. It's paying attention, getting involved. Know that you are an expert. You may not be a traffic expert, but you know your community. You know that it takes 3 signals to get through a specific intersection. So this is your chance to get your community-based knowledge and apply it to different projects around the community that are being heard by both the Planning Commission and the City Council. Or if you want to go there, the Board of Supervisors. So for this, thank you, Kevin, for driving up from San Diego.
Can I move this keyboard here?
Absolutely.
Melanie, thank you, and SPON members, thank you for having me here. It's always an absolute pleasure to be talking with people from a community who are willing to put in time to look after their community interests. And it's always a pleasure to have council people, former council people, wannabe council people also to have a chance to talk to. Because CEQA is a law which, because it fundamentally requires accountability for impacts, is a law that people and sometimes lead agencies are trying to not follow for various reasons. And I wanted to comment in terms of your watch list presentation. That warms my heart because you always, always, always have to be paying attention to what's going on early, at the earliest possible stage. Because these projects have a way of getting their own momentum, because the developers aren't going to start spending a lot of money on a project until they feel like they have the support of at least a majority on the city council or the board of supervisors for the county or whatever. So they've already got, before you ever hear about it typically in terms of a public notice, they've already have winks and nods and votes counted that this project is going through. And once they have that, it becomes very, very difficult to get anybody to rethink what exactly they're doing because they've sort of made up their mind, the city or the county or the state agencies made up their mind, and they begin to craft everything to get the project through with often the least sort of consequence in terms of obligations for the developer or the project applicant. And so the earlier you find out about something, the earlier you start asking questions, the earlier you start putting information into the process, even if they haven't formally noticed a public hearing, the better off you are. Because sometimes early issues, if you get them inserted, maybe they might deal with it early on and you don't have to be fighting it 6 months later or a year later or 2 years later in court or whatever. So your watch list is golden. Great job, Jim. I was listening with great detail here, or listening in detail to your presentation, and this is what people need to know, and you need to engage now. You need to engage yesterday in terms of these projects. So that said, I want to also comment and make a couple of overview statements regarding the California Environmental Quality Act, which a number of you have heard about and so on. In fact, let me ask, how many people have read an EIR? Okay, how many of you have read a neg deck? Okay, all right, very good. That was my impression. I've got a sophisticated audience, and I'm going to do my best to put together a whole lot of dots that perhaps you, in your efforts to look at documents and listening and participation, haven't connected. And I can tell you right now, you're going to hear stuff you know, but I need to lay that out there to connect the dots for you. But let me just tell you this. One of the most conservative laws in the state of California is CEQA. Say it again. One of the most conservative laws in the state of California is the California Environmental Quality Act. Because what it says is, don't change anything until you know what the impacts are going to be, directly and indirectly. So in terms of a fundamental definition of what's conservative, that's it. Now, it just so happens that that approach is also one of the most important taxpayer protection measures in the state of California. Because if it's properly applied in good faith, the impacts are assessed and the developers are required to avoid or to mitigate, you're not looking at a future of taxpayer supplements, if you will, for that project. So for example, if the project goes through and it needed an extra light, but the developer isn't required to pay for the light, well, who ends up paying for that light? Eventually, it's the community, it's the taxpayer. You pay for it potentially because the city is using its revenues to pay for it. You pay for it by sitting through, as Melanie alluded to, 3 cycles of the light, and your time is taken. And when I look at these things, and this is on the subject of connecting dots, when your time is taken sitting at a signal like that, what you're doing basically is you're supplementing the developer who put in that project. In other words, you're subsidizing the developer because of the fact that in the beginning, they didn't pay for what their impacts were going to be, and later on, you live with it either in terms of consequences on the quality of your life or in terms of your pocketbook as a taxpayer in the city. So seldom do people hear about the law in this sort of big picture context. But I'm here to tell you that that is very true. And there's a lot of people who I know who consider themselves very wise conservative types in terms of their worldview who will kind of say, what are you talking about? You know, but you just have to pull them, at least in my experience, you have to say, okay, let's just go through this and let's connect the dots. Because what we need to do right up front is we need to figure out what the impacts are going to be, and pursuant to CEQA, you try to avoid them, and if you can't avoid them, then you mitigate them completely. And if you can't mitigate them completely, you mitigate them as far as you can. And the law provides that if you really can't get rid of all the negative impacts through all that effort and so on, then you provide, or the city council or the board of supervisors adopts what's called a statement of overriding considerations, where they say that here are all the benefits for the project. We think that these outweigh, the negative parts, and we're going to go ahead and adopt it. So CEQA does not require a decision either way on the merits. What it requires is a process where everybody gets informed and everybody has the opportunity to comment and participate. And then the decision makers, and of course this is the theory, sometimes it works, sometimes it doesn't, but the decision makers then have all the information they need to make a decision, and in terms of public policy, they're elected officials and so on and so forth. Often though, the project gets wired real early on, as I was alluding to earlier, and they're not making any decisions other than just sitting there and look like they're paying attention, and then they go ahead and they vote for the project, and then they move on. So the example that I like to give in terms of this context that sort of puts the point home is that when the decision makers don't insist on, as leaders of a city or a county or whatever, don't insist upon a comprehensive report, they're making value decisions, a comprehensive environmental impact report. They're making value decisions in that process. So for example, let's say you have a project that's in a high-risk fire area, and there are serious problems regarding your ability to evacuate the project. And we'll be talking about one of these a little bit later on this afternoon. And you can actually, the experts will tell you that, okay, it's not a good way to build the project here. You need more access, you need a different layout in terms of the site plan and all that. Otherwise, you're creating risks for the residents in terms of evacuation abilities. You're creating risks for the first responders in terms of getting in there and having to try and save people, and so on and so forth. So taking that line of thinking to a logical conclusion, projects have a certain risk factor that they present to the life and safety and the health of residents that are there, that are going to be next to the new project, the people that are in the new project, and then the first responders who are going to be coming up to the project to try and put out the fire or save the people or whatever. So let's just say, for example, the combination of the design of the project results in a 25% increase in the chance of fatalities in the course of an evacuation. And you can do that calculation, okay? Now, how many decision makers want to publicly deal with that fact when they have all this pressure to go ahead and approve and move a project through the pipeline and build the homes and get the tax revenue or whatever it is that's motivating them to do it? So seldom does anybody in the state of California, even today, in light of all the fire issues, all the evacuation problems, and most of the deaths occur as a result of evacuation problems, seldom do you have environmental impact reports and neg decs, if it's an issue, looking at that level of detail. Why? Because the decision makers don't want to get to it. They don't want to get to it. So going back to the beginning of the process that we're going to be talking about here, the goal is to make the decision makers confront the facts and then make a decision. And if they want to make the decision that it's okay to have a 22% increase in the risk of fatality, great, good for them, if that's their priorities, but let's make sure everybody knows it and they can be held accountable if you think it's a bad idea as another member of the community. All right, with that backdrop, let's go ahead and let's turn to this. Oh, yes, Miss?
So can I ask you a question? So I've written letters like that on EIRs, and what I get is just have them in response. It's like, here are facts, this is factually true, and what you get in the response to comments is blah, 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 blah. So how do you get them to actually acknowledge facts that are true when you write a letter that is factual and they don't acknowledge that fact?
Often you have to just sue them.
Okay.
No, that's a great question, and let me answer that as we go through this process here this afternoon. But I mean, that's my life. I don't get involved where there have been accurate assessments of projects. You know, they come in, and it's just amazing what, and I can see nodding heads and everything. It's amazing what they'll throw back at you. And in my household, when my family was growing up, we used to kid about what the dog heard. You know, the dog's nickname was Hunden, and it was like blah 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 Hunden. You know, in other words, that's all she heard her name, but she didn't hear anything else. You know, so that's kind of by analogy what you often see in these documents. So, all right, so let's look at chapter 1 here. Okay, this is from a CEQA workshop booklet that I have used, and other people involved with the Planning and Conservation League have used for a number of years. We give day-long workshops around the state on CEQA. The basis for the outline for the program is in a 100-page document. This is about 40 pages from that document. And I want to go through the essential elements, if you will, of the law. And again, bear with me to the extent you've heard certain things, but we have to connect dots to make sure that you know, everybody is maximally empowered here in terms of going forward. So I'm going to walk you through fairly quickly here this. I'm going to point out a few things, and then what you need to do is you need to read the whole thing. And then the entire booklet can be available if you want to talk to Melanie about it. It's about 100 pages. It's in color. It's a little bit better formatted than this rough copy. Which is my responsibility. I was doing it in my office without any staff the other night, so I didn't get it quite so clean. So, all right, so chapter 1, we go to the first page here, the power of CEQA. And there's a general discussion here of a lot of good observations from former Supreme Court justices and so on, talking about how this law is just fundamental due process for the environment in the state of California. And how important it is with all the roaring economic engines we have. You know, thank God we have them. With all of those engines roaring, we have to keep things under control. And we have to make sure that the environment is protected, that there's notice, and that people can stand up and speak for the environment. And the environment includes other people too, by the way, not just critters and trees and all that. It includes people and how our project is impacting the people. So I commend that section to you, just flipping through page 7, purpose of the guide. And then on page 9, I hate this flow chart. How many people have seen this flow chart before? Okay. I mean, look at that. Isn't that like, oh my God, I don't want to read that. And so we will, if we have time, we're going to come back to this. But I fear that it often deters people from really saying, okay, I'm going to dig in here. And it's like, wait a minute, all these steps and all that. But I'm going to try and lay it out in more simplistic terms. After you've read this handout here, and after you've had this session, do go back and try and work through it. But you need some foundation to help you get prepared with some level of confidence that you can understand it. Page 10 is a really good discussion about public participation and how important it is and what role you prepare for in connection with a project. Looking at page 11, balancing environmental protection and social and economic benefit. That's a general reference to the fact that CEQA doesn't require you to make a decision in a certain direction. You can make a decision and just say, look, the environment is great, but in this context, we got many, many overriding considerations, so we're going forward with the project. So that's an important thing, because a lot of people will say, oh, well, this law is being used just to stop development and all that. And I said, no, this law is being used to educate the public and the decision makers so they can make a smart decision. That's what we're trying to do. So, and one of the reasons we have all the bad traffic we have is people make all these decisions that they want the projects and they don't really prioritize the traffic issues. So, okay, so then we're on to page 12 here, and this is on the project subject to CEQA subject. And so a project is an action which will have a direct impact on the environment, or a reasonably foreseeable indirect impact on the environment. It's not just a project, but it's a discretionary project that's covered by CEQA. So if there is a permit that's needed and you need a vote by a planning commission or a city council or board of supervisors or whatever, typically that's a discretionary project. A ministerial project would be, oh, well, I've got 40 acres of land, I want to put a fence around it. What's the code? It can go 6 feet high, it can be chain link, it has to have certain footing foundations, et cetera, et cetera. As long as they come in within the standards in terms of proposing to build the fence, that's a ministerial project. The city or the county can't say, oh, you can't build that. Now, if you want to build a Walmart, that's a different story. That's a project that's going to have an impact on the environment. And there's an approval process that you have to go for, and that's a discretionary project under CEQA, and that CEQA is what CEQA looks at. So you have an outline here of the definition of the project on page 13, which I've gone through. Discretionary, ministerial. They have this whole category of statutorily exempt projects where they list certain projects and they say, okay, we've decided that you don't need to do CEQA review. One of the most notable ones is listed first here on page 15, submittal of a voter-generated initiative or referendum to a popular vote. So you don't do CEQA when there's a project that's been pushed through with an initiative. This is something, a law that's been used and exploited and is still being exploited around the state, often by Walmart, for example, where they feel they can't get public support in terms of everybody going to a city council meeting and saying we want to do this and the councils are going to vote for it and so on and so forth. They have to go directly to the public to collect signatures. They often misrepresent to them what they're doing so they can get the signatures, they get it on the ballot, they get it approved, the council can't do anything about it. So that's an area Melanie was talking about. At the state level, we're looking at reform of the law on a number of different points, and that's one of them that's often exploited. And this is an interesting area. I urge you to read through this. It shows you sort of what politics does at the state level. Because, for example, you know, a big giant sports arena doesn't need CEQA according to the legislature, okay? They've exempted it. And there's other things they've exempted, like bicycle transportation plans and so on and so forth, where it makes sense. But it's an interesting read. Then after statutory exemptions, which are pretty much lockstep, you can't challenge them. In other words, if the statute says this type of project is not covered, then you're done. But the next category is categorically exempt projects, where if you can show that there actually are going to be unusual circumstances and unusual impacts, even though that something is listed as categorically exempt, then you have the ability to force an environmental study under CEQA with respect to the document. And again, I commend this list of exemptions to you. It's an interesting read. If there's going to be a declaration of an exemption where somebody, a city or other lead agency is looking at the project and they say, okay, this falls under this exemption, we need to give the public notice that we're basically acknowledging that this exemption exists and we're not going to go forward with the CEQA process. So that's discussed on page 17, notice of exemption. There's a 35-day statute of limitations for a lawsuit. If somebody issues an exemption and you say, wait a minute, that doesn't sound right to me. If you're going to challenge an exemption decision, you really need to go to a lawyer, by the way. I mean, you can try it, but one of the problems you have is that this law, due to the contentiousness of it, there are so many pitfalls that have been legislated into it as a result of what's gone on in Sacramento. That even a lawyer is at risk if they haven't done these things a lot and taking on one of these cases and then missing something and then getting kicked out of court. So there's lots of quicksand that's been laid out. And so if you're serious about something, take the time to get some legal advice from an expert, and because you'll not regret it because you won't end up getting thrown out of court or whatever. So let's assume there's no exemption and you've got a discretionary project. And then the process becomes one of going through, and I'm looking at page 34 now, chapter 4, an initial study. And you have a couple of initial studies in your packet. If you thumb through that, we'll be talking about that a little bit later in terms of actual substance related to a study in relation to a particular project. But the initial study is one that is supposed to take a look at, all the potential environmental impacts. And there's another document in your packet called CEQA Appendix G. And this is basically the foundation for the initial study, and it identifies all the areas that are generally of concern in connection with a project. So how many people have heard of Appendix G? Okay, all right, a handful here. So let's take a minute and flip through this, because this is a neat document, and this is, if somebody said, you know, tell me one document that somebody needs to, yes, miss?
Make sure they got
That's the third handout.
It's the third handout. This is it. Says Appendix G.
It's separate.
Oh, okay.
Thank you. Sorry.
Yeah.
Thank you for that. Okay, yeah. Please raise your hand if I'm not properly cueing people. I want to make sure everybody's following. So if there was a document that I would want people to really understand, this is it, in terms of the process, in terms of what you look at, in terms of a project's impact. So the first few pages are basically sort of a summary sheet where they say, you know, what's the nature of the project, what's the surrounding land use, and then they have this summary on the first page, and going on to the second page of boxes of different impacts, whether you're going to check as to whether or not there's significant impacts or not. But wandering through to page 247, so that's page 4 in this packet, this begins the actual detailed checklist. And let's look at aesthetics here just because it's the first one. Have a substantial adverse impact effect on a scenic vista. And then they have boxes. A potentially significant impact, less than significant with mitigation, less than significant, no impact. So the role of the lead agency is to evaluate the project and check one of these boxes in each row with respect to all the listed impacts. And so just to walk through quickly, we got aesthetics, we got ag resources, we got air quality, moving on to the next page, biological resources, and then we have cultural resources, geology and soils, hazards and hazardous materials, hydrology, water quality. Keep rolling here, page 251, land use and planning. This is an area that CEQA requires you look at in terms of consistency with specific plans and general plans and other laws. If there's an inconsistency in terms of the proposed project with your general plan, then that needs to be addressed and discussed frankly and comprehensively in an environmental document. And that is in and of itself a significant impact, often negating the ability to do a negative declaration. Yes, sir?
You said the lead agency, who would be an example of the agency and the person that would be doing this in the agency?
It would be the planner assigned to the project in the development department of the city.
So like in the city of Newport Beach, would be a Newport Beach planner.
Right, right, exactly. And often the project applicant is there whispering in their ear about, you know, there's really no geology issues. Yes, miss?
A consultant is preparing this as well.
Yes.
Consultant to the applicant or to the city.
That's correct. That's correct. One of the things we see around the state is a great variety of levels of participation by the project applicant with the lead agency staff. And sometimes, you know, it's the lead agency, in my impression, shouldn't even be in the way. It's just like the developer is calling all the shots because that's the politics of the city or the county or whatever.
So can that be challenged, or is, you know, can another group come in and say, we'd like to see the Appendix G?
You have the right to see any of these documents.
And then can you kind of challenge their?
Yes, you can. Yes, you can. And we'll be talking about how to do that.
Yeah, okay.
So, good questions. So, all right, so I'd stopped on land use planning, but just to roll through, mineral resources, noise, population and housing, public services, recreation, transportation, utilities and service systems, mandatory findings of significance. So, if you were going to get ready for a test, you know, on a particular project, you're supposed to analyze it, this is what you'd want to look at. And say, let's think about the utilities, and let's think about impacts on, you know, the geology issues, and let's think about this. And so these are all fair game in terms of a project, and often there will be spins in terms of what the impacts might be by the applicant or a consultant or whatever, and then there'll be some hesitation in terms of which box is checked, you know, by the staff person. The goal for the lead agency and the applicant is to avoid doing an environmental impact report. Because one, it costs money, okay? And fair enough, right? Fair enough that, as a business person, you don't want to have to spend any more money than you have to. And EIRs can cost, $50,000 or $100,000 or $250,000, depending on the size of the project or whatever. And so they want to avoid that. So I get it. It's fair. We have a system. We want free enterprise where it makes sense. So then also, they not only don't want to have to pay for it, they don't want to deal with the consequences if the report comes out and says there's going to be all these unmitigated impacts that the developer is going to have to mitigate. So again, human nature, fair enough. If I can get away with not having to pay for a new stoplight, then I would like to do that as a project applicant. Right? I don't live in the city. I'm going to build my project, or I'm going to sell my approvals, and I'm out of there. So I really don't care. And that's not, I don't mean to overly generalize, that's just often what I see in terms of projects. There's plenty of good developers around the state, in Southern California, et cetera, who try and do it right, and not overdo it in terms of a sort of robber baron mentality where you come in, you sell, and you take your money, and then everybody lives with the consequences of not being able to evacuate a project or something like that. So the goal that you have in connection with this process is being into it as soon as possible. So it's nice to be paying attention when the initial study is going on. And that is before you ever get notice of, for example, preparation of an EIR. In other words, this initial study process is something that they do early on, and then that begins to direct them in terms of what they're going to do in terms of further environmental studies.
Kevin?
So, yes.
I just want to mention, in terms of early information, the city of Brea provides a development report to the Planning Commission, and so that could be your earliest notice, is requesting that report to see who's come to the city to find out about what applications are pending. And it could be something like a conditional use permit, but it could also be a big project in the downtown or something. So that's another way, is to request that once a month and see what's happening.
So what happens when there's a discussion or there's a debate with the representative in the development division, the planner, who is trying to decide which box to check? And the one that you want them to check, if you're concerned about a particular area, is potentially significant impact. That's what you want them to check. Because if they're going to check less than significant with mitigation, then that means you don't have to do an EIR on it. You don't have to do a full study on it. We're going to just basically say, we're throwing in a little bit of extra traffic impact fee, and that's enough to mitigate for this particular problem. And again, the thinking is, well, if we do that, then that doesn't require an EIR. And sometimes, there are legitimate public policy reasons for a city wanted to move a project through quickly to get it approved. They're not so much concerned about, the impacts on the developer, but the city really wants the project. And so then it filters down. The city council makes that clear. The city manager makes that clear to the staff. And then the person that's deciding which box to check there, has a certain amount of, nudging in terms of what they're supposed to be doing. Okay, so potentially significant impact. Yes, Miss?
Yeah, what you just said, I'm wondering who in the city decides that they want the project, and then goes the developer. You just mentioned it comes from the city as opposed to the developer.
So what happens is the developer brings the project to the city and gets the nods and the winks, from the city council people, so they know they have the approvals, and so then they submit the application. The city manager knows, through nods and winks or direct communications, that this is a project that they want through. And in some cases, the word is, let's get it through quickly, because we need it for whatever reason. There may be a really good reason for it from a public interest standpoint, but then there may not be. So it depends on the project. So what's a potentially significant impact? And this gets us to the heart of CEQA. If there is a fair argument that there may be a significant impact on the environment, then you need to do an environmental impact report. Okay? If there is a fair argument that there may be a significant impact on the environment. So that's a really light trigger, properly understood and applied. And so your goal, if you have concluded or preliminarily even think that, look, they're trying to short circuit the full environmental review process, this neg-dec thing, which is a limited document that doesn't study a whole lot of issues, is just not going to be enough. We need an EIR. Then your goal is to make a fair argument that there may be a significant impact on the environment. The way you do that is you have to come up with substantial evidence. You can see, non-lawyer, your eyes could just sort of glaze over. Substantial evidence, what is that? When I get involved and people are serious about forcing an EIR, I'll often go ahead, and the city wants to do a neg-dec, which is a limited and complete study. I will go out and I will hire an expert or two or three to come in and give their expert opinions. And that, as a matter of law, is substantial evidence. And so I put that into the record, and if they're going to proceed with the project, doing a negative dec rather than a full environmental impact report, they're really in trouble. And this is the kind of thing where it's like, okay, make my day. Because go ahead and let's try this out, because we're going to go to court, and 9 times out of 10, I'm going to win. Because I put into the city record substantial evidence in support of a fair argument there may be a significant impact on the environment.
Could you define negative declaration real quick, sorry?
Sure. It basically, if you refer back to this list of boxes, is there a potentially significant impact, less than significant with mitigation incorporation, less than significant impact. Basically, if they're checking anything other than potentially significant, they're saying, okay, this is something we really don't have to worry about, and we're not going to study it.
And the negative declaration is what?
It just basically says, we're declaring that there's no impact.
Because here's a
Yep,
whole packet about it.
that's right, yeah.
So they make a whole packet saying,
They just have, they have all the categories, and they just go through and say no impact, and maybe they have a paragraph.
You have to explain your answers, though. You have to explain the answers. I mean, or you'd be really stupid not to.
well, yeah,
Yeah.
okay, got it.
Right. Thank you. No, thank you for asking that.
Guarantee lawsuit.
Right, yeah, exactly. So, in any event, you don't have to have expert letters or testimony or whatever in order to put forward a good strategy to force a full environmental impact report. You can, as citizens, you're capable of putting into the record substantial evidence. Now, what is and what is not substantial evidence? So, if you get up and you say, the traffic is horrible on Bristol, and you need to do something about it, and I can't live with it anymore. Okay, that's not substantial evidence. Okay, but if you say, at 7 o'clock in the morning, I get in my car, and this is what you write in your letter, or you say to the city council at a hearing, or the planning commission, or whatever, at 7 o'clock in the morning, I get in my car, I have a half an hour to get to work, I go through this intersection, and 9 times out of 10, I sit through 3 cycles of the light. And maybe, for example, if it's true, you live nearby and you happen to hear every time there's an accident there at that intersection. It's a serious safety issue in terms of that intersection, and adding more traffic to it is going to make it even more of a problem. So you say, yes, I was out there, let's say 2 months ago, and I heard this crash, and I turned and looked, and there was this vehicle collision, and these were my other observations regarding it. It's a dangerous intersection. That's substantial evidence, okay? Facts that that you put forward. And so once that's there, then the person who is wavering between the concept of, all right, well, do we really want to go ahead and do an EIR? You're starting to box them in. And if you show that you know what you're talking about, if you have a lawyer, shows you're serious. And I'm not trying to talk full employment for lawyers here. I'm just telling you that there are certain, because this is so complicated, you got to be real strategic about it. And, the things change in terms of how a city is addressing a project or a county if they know the other side has an attorney. Or at a minimum, they hear the other side talking about, the people that are concerned about the projects, talking about things in a way that they are creating substantial evidence and everybody knows it, including the developer. So, yes, sir.
I got lost on the then of the if-then. You're saying if it might have a significant effect, then
You have to prepare a full environmental impact report.
then it has to have a full EIR?
Yes, correct.
Okay, thank
Yeah.
you.
Yeah. So in other words, you don't have to, what they like to argue sort of generally is that, oh, well, that's just an opinion, because we have experts over here who disagree. So the beauty of the law is the fact that if there is a dispute and there is a fair argument in support of the concept that there may be a significant impact on the environment, then you got to do the full study. Yes?
As I recall from the last general plan, traffic things are talked about in there, that there will be no worse traffic signal than an E. And so it's those kinds of things are already addressed in the general plan, and all you have to do is say, the general plan says, and that's evidence, right?
If the general plan has, the general plans often.
And ours does.
Okay, yeah, so if they have specifics like that regarding certain locations, that's definitely something you can use, especially if they haven't referenced it as something that they've considered. So, depending on the general plan, you have your goals and your policies and so on that are listed, but then often they'll have footnotes or they'll have the explanatory sort of text, and all that is something that you can use to reference when you're making your arguments in connection with that. So, in any event, we were on page 25 of the handout. I just talked about substantial evidence. Again, read all this. I'm covering this in some level of generality. And now we're on chapter 5 here, 27, in terms of the handout. And this is specifically, what is a negative declaration and what is a mitigated negative declaration. But, and I commend this section to you to read. It, basically is what I said. If there's not going to be an impact, then you just do a negative declaration. There's going to be no impact. If there's going to be some impact, but you think you can mitigate it, then you adopt a mitigated negative dec, which says no impact, no impact. Oh, and on this, we're going to do X, Y, and Z, which is going to mitigate it, so there'll be no significant impact, and we're moving on. So, again, read this section. It's got more detail. Moving on to the next page, 29, public review of negative declaration or mitigated negative dec. It covers basically the process and how you get involved and how you comment, how you begin to put evidence into the record of a significant impact on the environment. So chapter 6 now basically talks about the environmental impact report process. If the lead agency decides to do an EIR, then, and again, I'm looking at page 32 now, they have to prepare a notice of preparation, which goes out and it says, there's this project, we want public comments about what you think we should be looking at. You definitely want to be in on this stage where you're going to raise all your issues formally and get them submitted in writing or at a hearing to the lead agency. And you're focusing on what needs to be considered, which is generally referred to as scoping in terms of what all is going to be looked at in the document. Yes?
So what I'm understanding is that when our planners have checked off significant or not significant, once they've decided they're going to do an EIR, when it gets to the scoping part of it, that's when we have the opportunity to expand what they've checked off. So if they've checked off only one box of significant, but we come in and say, you should have checked off 17 boxes, they're stuck doing an EIR on those 17 boxes.
If you put in substantial evidence in support of a fair argument that there may be significant impact on the environment. Okay. Okay. All right. So there's a discussion here, page 34, preparation of the draft EIR. That is prepared, then it goes out for public review and comment. And this is a very important period of time because when you, within that formal comment period, and it's normally 30, 35, could be up to 45 days for the public to comment, they have to respond in writing to your comments, okay? As long as your comments come in during the public review process. So this is a very important time where you want to be on it. And depending on the complexity of the project, if the people have come to me, earlier than this stage, sometimes I get called up saying, by the way, there's a project that was approved 3 weeks ago by the city council and we're concerned about it and we understand the deadline to file a suit is next week, can you help us? And it's like, okay, wonderful. The lawyers who do this stuff, we want to be involved as early as possible because we can help give advice and direct and save time and energy too in terms of what you're doing and how you're doing it. But absolutely, you need to be involved in submitting comments during this period to force them to respond in writing to what you're saying. And as was alluded to earlier, sometimes the responses are just pure gobbledygook. Yes, sir.
Can you explain more about the tiered EIR process?
No. I can, but it would take a long time, and that's something that basically this whole series of you see here 6.4.1, 0.4.2 talks about other documents that have studied some of the same issues. And so what you do is you build upon that analysis in the next level of environmental review. So there may have been an EIR for a specific plan, which is a big area that's been planned. And they looked at certain issues. And so you don't have to go restudy all those depending on how it was done. And you then rely upon that as a foundation for your subsequent report that you do. So that's the basic concept. But
our general aviation EIR is going through, is that they're doing a master plan EIR and then they don't have specific projects involved, and they'll come back and do those later. Is that
that's right, exactly.
Okay.
That's right. And so there's all these different, I've just explained the tiering concept, but then you have project EIRs, which are normally project specific, program EIRs, and master environmental impact reports, which are for airports and special districts and big areas where they're studying things. So it's an attempt basically to avoid the need for sort of duplicate analysis and study and everything. They can just refer to this program EIR that was done 5 years ago, and these issues were dealt with, and this is what we're assuming.
But it helps avoid the real project too. You get a sort of a masking of a general or a master EIR, and then you come back in, or the proponent of the developer comes back in and relies on the master EIR and says it's already approved, sort of thing, right?
That's exactly right. There's often a shell game. In other words, that they do the program EIR, and then you say, well, wait a minute, you're trying to do a project EIR, and they say, but it's been studied here, previously, when in fact it hasn't. Or you go in and you challenge the program EIR and say you have to study this, and they say, no, we'll do that at the project level. Okay? So there are unfortunately games played with that. And the developers don't get away with that if the lead agency is doing its job. But that, some 50% of the time. No, by the way, hold that question for just a moment. What I was going to say is that there's only approximately 1 to 2%, depending on the year, of all of the discretionary projects subject to CEQA in the state of California are litigated. 1 to 2%. It's a small number. And there's a whole, but you always hear, the developers and those interests are always complaining about CEQA because it costs some money and because we want them to be held accountable. So, yes?
Back to the comments. Do they have to be supported with substantial evidence?
Yes.
What's the formality? So the comments clearly have to be.
Yes.
Okay.
Yes, and sometimes you get issues that really require an expert. So for example, contamination, which it can be a very complicated issue. And you would be surprised at the number of projects that I've seen over the years that have sort of hidden contamination issues. And so you often need to bring in somebody who specializes in that. I work with, for example, somebody who does cleanup of polluted gas station sites, who really knows his stuff regarding all the chemicals and all the pathways to impact the public health and all that. And that, you know, contamination can be a very good showstopper, if you will, for a project, because that, if a site is contaminated, that can cost a lot of money to evaluate and a lot of money to clean up. And I'm sorry to say, I've seen many times where developers have known a site's contaminated, and one of the reasons they don't want to do an EIR is because they don't want people to know about it. So, and Melanie, how are we doing on time? I started.
We have until 3:45, I think.
We have another half an hour. Okay, all right. So I just let me tell you one quick story about contamination. There's a botanical gardens down in San Diego. It used to be known as Quail Botanical Gardens, now known as San Diego Botanical Gardens. They came to me in 1994. They said, the nurseries in front of us, and that's their western ocean view from Quail Botanical Gardens then, now San Diego, the nursery wants to sell out and they want to build homes there, and we're concerned they're going to take our views when they build the homes up. And they said, you know, we've even offered to take soil from the nursery so that they could build lower and not build the house, have houses up so high, interfering, you know, with our views and the public views and all that kind of stuff. And I said, well, you got to be careful about taking dirt from a nursery, because they're kind of well known for having thrown around DDT and toxaphene and all kinds of stuff over the years that don't go away real quickly in the soils and so on. So I looked at, and they were processing this neg deck, which included conclusions that there was no contamination. And I looked at the actual sort of soil studies that they'd done, and they had tested everywhere you would expect not to find contamination on the nursery site. Okay. So we went to them, we raised the issue, nobody cared. The applicant was politically juiced, the council, they were all drinking buddies and all that kind of stuff. So the project went through. We sued them, we won. They had to go back and start all over again. They did we went on a number of different issues, but they came back with respect to all of them and tried to do a fix. And then with respect to the contamination, they did another bogus study in terms of their methodology, in terms of their sampling technique. So went through the process and was on the verge of being reapproved, and had an opportunity to talk to the developer and some of his consultants before a city council meeting. And I said, you know, you understand that we're going to sue you again. You know this property's contaminated. We're not going to give up on this. And should you ever have a chance to grade the project, we're going to be out there picketing with skull and crossbone signs, so everybody who's out there working knows that it's polluted. Should you build models, we're going to have literature out there for everybody who's coming to look at your models. And should you actually manage to build and sell the project, we're going to be knocking on doors a year later and asking whether there's any clusters of illness in the families for the young kids and so on, because they're out there in the yards and so on and so forth. At which point they huddled and they came back and they said, what do you want? And we said, what we want you to do is we'll let your project go through, we'll stand up and support it, you just have to agree to do these studies we want you to do. And they said, okay. So what happened was it was approved. We approved the methodology, the consultant, the lab, looked at the reports. They had to strip 5 feet of soil off of 40 acres because it was all heavily, heavily contaminated with DDT and toxaphene and so on. So that's an example of, the developer was willing to have families come in there, play in the garden, do everything they're doing at a home, and they didn't care about the consequences in terms of public health, which is just, I tell that story because it's shocking. But it's also an example of how you as citizens can stand up and say, look, this is a problem and we need to approach this differently from the standpoint of what's right, from the standpoint of public health, from the standpoint of the environment, and so on and so forth. So anyway, back to chapter 6 here in terms of the contents of the environmental impact report. Again, you need to read this, but all of the same categories in Appendix G have to be addressed in the environmental impact report in terms of environmental impacts. However, in addition to those specific environmental impacts like biology and geology and aesthetics and so on, you have to look at a number of things that are in addition, that are relevant to overall good planning. So is, for example, a project growth inducing? If you build this, let's say it's out in an area where there's not a whole lot of building, and the developer's going to bring water lines and utility lines and all that out to this location. Well, normally, if that's going to happen, there's other properties around there that are potentially going to benefit from being able to tap into those. So that's called basically growth inducement in terms of what you're doing when you're creating the infrastructure to facilitate and encourage additional development. So the law requires that there be an honest discussion of what next development is likely to be encouraged and facilitated if you build this particular project. A similar concept of significant importance is cumulative impacts. So they may say, well, the impacts from this one project are not that much, but then there's a project 2 miles away to the west, and there's one 3 miles away to the east, and cumulatively, they're all going to, for example, overload the off-ramp that everybody goes to get onto whatever it is, 5 or 73 or whatever. There's not a whole lot of free-flowing on and off-ramps, I know, in Southern California. But in any event, cumulative impacts are very, very important. Now, what's really, really, really important from a good policy-making decision standpoint is project alternatives. And so the EIR, and this is often why the developers strain to avoid a negative deck. Because if all you have to do is a negative deck, all they're doing is saying no impact on biology, no impact on traffic, whatever. The neg deck doesn't talk about growth inducement. It doesn't talk about cumulative impacts, and it doesn't talk about alternative project designs. So those areas are typically the main things that the developers want to stay away from because of the fact that they just don't want those issues considered. They don't want, if they want to build a 200 home residential project, they don't want somebody saying, please, let's reduce it to 100 homes or 150 homes or whatever. But the law requires that if you have a project that may have a significant impact on the environment, you have to look at alternatives. And typically, if it's a residential project, you have to look at various, not only numbers of units, so they want to build 200, they need to analyze a couple of sort of reasonable alternatives, which would maybe be 150, 100 homes. In some cases, an alternative might reasonably include staying away from a particular area or having a different footprint. Same number of units, but it's a different footprint. And then there's advantages to that different footprint. So you always want to look carefully when you're dealing with commenting on an EIR about how well they've done the alternative section, how well they've done the cumulative impacts. Sometimes the evidence you're putting in the record dealing with cumulative impacts is evidence about other projects. Because you're aware of the fact that there's a project to the west and one to the east, and they're all within this reasonable radius, and they're all going to have a synergistic effect on traffic and so on and so forth. Sometimes that's the evidence you're putting in on that. Just as you could put in evidence on what might be a better alternative. Let's say that they chose 3 alternatives. There's always a requirement of studying a no project alternative, by the way. But maybe there's an alternative that you think that makes sense, then you want to put that forward as something they need to study. Now, at that stage where you're commenting on an EIR with alternatives in there that you're dissatisfied with, you probably want to have some level of professional guidance on issues dealing with cumulative impacts, growth inducement, etc. And that can be done through a planner. I often work with planners who are able to supplement what I know and supplement my time. They don't cost as much as a lawyer. And they can put in some really good comments on those topics. And if they're done well, then often you'll have some adjustments or at least some detailed explanations in terms of the responses to comments. So in terms of the rest of the document, let me just point out a couple things, and then I want to move on to a couple of project specifics. Looking at page 37, this is on the subject of subsequent and supplemental EIRs. So this is where you've had an EIR done, the project was approved, and it's just sitting, and then they come back 5 years later, or 10 years later, or 20 years later, and they want to do the project. All right, so then, you know, what you want to be saying is, if you're concerned about the project, is, well, you need to do new environmental studies. You don't need to do a whole new EIR, but you need to do a subsequent or supplemental EIR, depending on the circumstances. And the grounds for requiring a subsequent or supplemental are basically changed circumstances, the availability of new mitigation that wasn't available, or the unavailability of mitigation that was previously presumed, things like that that are material, if you will, to whether or not this project still has reasonable legs, you know, from an environmental integrity and public policy standpoint. So you can read about that too. There are gazillion cases, published and unpublished, on subsequent and supplemental EIRs. It's field day for the lawyers fighting, where the developers really don't want to have to they don't want to update the document. And again, good reasons on one side, you know, not so good on the other, where, you know, it's like it costs money, it's time. All these things are very important, legitimately so, for a business that's, you know, trying to develop something. But often what that means is that they're basically asking the lead agency to ignore recent developments that obviously affect the project and should result in there being adjustments to the project. Or in some cases, the project shouldn't even go forward unless it's completely revamped and revised. So, Chapter 7 is a listing here of all of the different sections that have to be in an EIR. And go through this when you have time. There's also sections that are required on economic and social impact, in addition to the ones I was mentioning earlier, cumulative impacts, alternatives, et cetera, et cetera. So if a project is a substantial one, there should be an EIR that really, in detail, looks at all of these issues. And if you're ever serious about stopping a project, if it's really, really not belonging where it is, or if you feel the project really, really needs to be revised significantly, then you need to definitely be working with an attorney to plot that strategy. And I'm not going to be talking about CEQA litigation other than making some passing comments on it. Most important thing you need to remember is that CEQA has the shortest statute of limitations of any law in the state of California. 30 days, baby, and you're out if you don't file that lawsuit within that time period. Yes, sir.
I've got a couple of questions. So back to your Appendix G, if a environmental impact report is prepared by a developer for a lead agency, it's prepared at their expense, what's the incentive for a staff person at the lead agency to find that it's not necessary on any of those boxes when they're not paying for it? Why wouldn't they just, what's the incentive for a staff person to find that it's not necessary?
To do further studies. Is that?
Yeah.
Yeah.
To say you need to prepare an EIR. Seems like it would let the staff off the hook if the EIR was prepared. So I'm curious why the staff, other than they favor a project, I'm not implying anything untoward, what would make them not check the box and say, prepare it?
The politics, basically.
So from somewhere up above, they're getting pressure to,
Yeah.
we want this project?
Yeah, and they don't want to do an EIR.
Okay.
And so that's.
Kickbacks?
Well, I don't know. I'm not making that allegation,
I
but
didn't.
I don't understand.
So, you know, and by the way, and remember, this is why I gave you the statistics, okay? There's suits filed 1% to 2% of the time on all these projects around the state. So we got tons of people that are doing their job, okay? But it's just often the really big controversial projects that are politically controversial and all that, where the pressures just skew the process, and the public is short-changed in terms of understanding what's going on and being able to participate, and having decision makers who are willing to grapple with the issues in a meaningful way.
Okay, good. Anyway, I have attended a lot of planning commission meetings with, and watched the reports from the developers. And there is one consulting firm that seems to be used in Newport consistently to do EIRs. I have never seen them say there's a traffic impact.
Which firm is it?
Huh?
What's the name of the consulting firm?
I don't have it, I don't
Place
know.
Place works.
How do you spell that?
Place
works.
Just like-
PLACEWRK. Oh, okay, I'm not familiar with that.
Anyway, it's so, and I'm wondering how to go back on that, because it's like whack-a-mole if you just take it by project. Is there a way to show that occurs with so many projects? Because traffic's our major
Well, I mean,
issue.
if you could get somebody to compile a list of that, to show that, then you should have a strategy to take it to the city through a friendly, wise, public interest-oriented city council person to be left unnamed. And, and say, here is a practice regarding the consultants that are being used that is not in the public interest. And so there's all kinds of variations in terms of how the lead agencies deal with consulting groups. And but it's a totally legitimate issue that you raise here that I would say be brought at the right time to the city's attention. Because if there's never an impact, then what are these people doing? And there's plenty of examples of consultants. It's just like what's the result you want?
Yeah, they hire that one that gets the result they want.
That's right. And and down in San Diego we have it was funny. We moved our offices from Carlsbad recently, but on the same floor we had one consulting group down at the end of this, the west end, and then we had another consulting group at the other end. One of them has a good reputation as having some level of integrity. The other one is just, you just pay for the opinion, and they'll give it to you. And it's really sad, but I mean, and it's not just in this arena, right, that you have this phenomenon. There's experts all over the place that are for hire, like lawyers. So, and by the way, on the subject of traffic, I remember sitting with some traffic engineers who were bitching about lawyers and, as advocates and all this kind of stuff. And all I wanted to say to them is that, well, wait a minute. I am an advocate, and I admit that I'm an advocate, whereas you guys pretend to be objective, and you're an advocate, And so, that's infuriating in many cases. So, but yeah, I encourage you to press that issue. Get a new consultant. The public and the city will be much better off in terms of, the integrity of the process. Okay, so that's all I had in terms of the handbook, but I do commend you to read this when you have time to go through it. If you're having trouble sleeping, read it. It will put you to sleep, and so on. Yes, sir.
Yeah, just on a cumulative impact, let's say you have project A, B, and C, and they're chronologically going to be in that order. So A comes in, there's B and C don't exist, but the potential for B and C are, say, in the general plan or somehow. Otherwise, can you use the future to imply cumulative impact? Future potential, or does A get in and B gets in, but C suffers the cumulative impact because they're the last one out of the chute?
Okay, if I'm following the question, if the project is more hypothetical than real, then often the lead agencies will justifiably say, well, we're not going to consider that. Yes, it's a possibility. But then sometimes it's a matter of you making the case that it's more than a possibility. And that may require some checking and sleuthing and all that kind of stuff in terms of how far along a project really is. In other words, it may not have hit the formal notice calendar, but if it's coming along and there's been all this preliminary work done and so on, then you want to bring that to the attention of the lead agency and say this really needs to be considered because it's a happening thing. And depending on the agency, they may agree with that and decide to factor it into their cumulative impacts analysis. But it is really, really common for the agencies and the developers to say, oh, well, that's too far away, and oh, that's not going to have any impact whatsoever in this area. There is no cumulative impact. So it becomes a matter of discussion and debate. Yes?
Do you want to go first?
We have, okay, sure.
Just because it's on the same question, but so the on cumulative impacts, sometimes it's true. So an EIR is prepared, and then you see things get delayed, and projects come and go, but coal will be an example of this, okay, because coal was stopped for a while or didn't go forward. And so in the EIR, it'll say something like, okay, the project began in 2016 or whatever it is. And so they stop the analysis at that point in time, and I've seen them basically say that, things are speculative. Well, they're no longer speculative today.
Right.
Newport Crossings is a good example. That is now got an EIR, prepared for. And so they don't go back and pick up those projects, but the administrative record runs until that is approved, correct?
That's right. The record that you sue on is being built until they gavel, down, or up the project. In other words, when they vote, everything that's come in before that is material. And so you're talking about the general area of subsequent and supplemental EIRs. There was one that was done a few years ago. There's new information, changed circumstances, and so on. And therefore, your pitch is you need to do a supplemental or a subsequent EIR.
They haven't approved it. But
Did they approve the EIR as opposed to the project?
They haven't approved either at this point in time.
Oh, okay. All right. Well, so then you're
The
arguing.
record's still running.
Yeah, right. Okay. Yes. All right. Yeah. Sometimes they'll approve the EIR and then the project approvals will trail.
Right.
So, yes.
The density bonus. So, one of the things that's gone on now is that if you do affordable housing units, you get a density bonus. So a couple questions about density bonus. First of all, if they're gonna do an EIR, I assume they have to include the density bonus. So if you're gonna have, you're zoned for 100 units, but you have, 35% affordable housing, you can get a much larger number. When they're doing the EIR, they do the EIR for the higher number of units,
Correct,
right?
correct.
Okay. So the density bonus is, as I see it, it looks like it's affected by zoning. In our general plan, in the airport area, they're allowed to add, pick a number, I think it was like 1,224, whatever it was. But they're gonna be able to, under Uptown Newport and, to add more units with the affordable, units. If the general plan sets a specified number, are they, with the density bonus numbers, are they able to exceed what the general plan says, or just what the zoning for the area allows?
That's a really good question. It depends on the specific laws. As a general proposition, the general plan should control. Why don't you, I'll stick around for a few minutes after we're done. It's a little bit far outside our scope here. But it's a good question and it's an interesting one. So, okay. So let's turn to the Esperanza Hills package.
Can I ask one question about
Yes.
cumulative impact?
Sure.
Because I had an example where I went up, it was at the planning commission before I really knew about it. Same developer doing a huge development next to it, but planning commission saying the two don't go, and I'm up there going, yeah, they should go. But I wasn't educated yet with your, so that should, I could have really pushed it a little bit more.
Yes.
Yeah.
Okay.
They just dismissed it. But the planning commission could have sent it back,
Yes.
even when it gets to that point.
That's right. Yeah, and that happens. Good planning commissions will do that.
Thank you.
Okay, so Esperanza Hills, has anybody heard of this project? Okay, so this is something that's been going on since 2014. They've been looking to build 340 homes next to Chino Hills State Park, basically to the south. They want to grade 15 million cubic yards of dirt to create view lots for multi-million-dollar homes, all right there in front of your view shed for Chino Hills State Park. So it's a great project, if you can tell by my comments. This is, and Millie, in terms of time here, I see we've got about 18 minutes left or so. So I'm going to roll through this and then do what I can with respect to the neg deck on the Milton-Nigel district. Okay, so these are some excerpts, if you will, from the EIR for this particular project. This is, by the way, prepared by CAA Planning from Aliso Viejo. And this is actually a case that's been in litigation since 2015. And I've been handling that litigation. But CAA is the bought and paid for consultant for the developer. And nobody has said anything at any time that CAA has agreed with, ever. ever. So we sued him once. We won on greenhouse gas analysis deficiencies, and they were stripped of their approvals. They had to come back and do it again. They didn't do it right. We had another appeal that was pending on other issues. Ultimately, we won that appeal on issues related to evacuation, water, and impacts on Chino Hill State Park. There were all these obvious problems and impacts, but CAA always was there arguing that we were, and they would often be obnoxious about, sort of contemptuous about the arguments and the positions that we would take. So this is an example of a bought and paid for consultant that's not out there doing anything other than representing the economic interests of the applicant. And it's just, it's terrible. And this is before the county of Orange County. We have several clients. Lead client is Protect Our Homes and Hills for Everyone, which is a longtime group looking after protecting Chino Hill State Park. California Native Plant Society, Friends of Harbors, Beaches, and Parks, who you might have heard of, and then the Endangered Habitat League. So those are the clients and all. So in any event, you see here in the table of contents all of the sort of detailed sections of things being broken out in terms of the impacts. But in terms of looking at an EIR, the first thing you want to do is you want to go to the executive summary. No big surprise there. And if that's done right, it really gives you a quick overview of everything that might be relevant to your world. And I talk about relevancy to immediate neighbors, I talk about relevancy to environmental activists, and then I talk about relevancy to citizens. And I use the term citizen where you're not just worried about the impact on your neighborhood, you're not just worried about the impact on the environment, you're worried about everything from a public policy standpoint. Because you should be, because it's your community and they need to make good decisions. When they don't do it, then you suffer and your children suffer, and so on and so forth. Project location, project description, and a summary of the actions that need to be approved for the project to go forward, known as discretionary actions. Again, I'm reading from the contents section under 2. Summary of environmental impacts, matrix of mitigation measures, impacts found not to be significant. Matrix for mitigation measures is something you really want to look at. And it'll give you an overview of what they're saying they need to do to mitigate. You need to form your own opinions based on, your research and other people's thoughts on that. Then after you've done that, you have your priority list of what you really want to dig into. So maybe you're really interested in biology, or maybe you're really interested in air quality, whatever. Then you go to the sections involved with that in the EIR and scrutinize and figure out whether you agree with it or whether you don't agree with it. So one of the, and I urge you really, in terms of looking at an EIR, if you want to challenge it, you need to do more than just read the executive summary and look at your particular sections that you're interested in. You need to look at the alternative sections and the growth inducement section and the cumulative impact sections and so on and so forth. Now, I want to comment that in connection with an EIR, when an EIR is prepared and certified, if you're going to challenge it, there are limited grounds to challenge an EIR. Remember I told you how much I love when somebody comes to me with a neg deck situation and we put evidence in the record and they don't want to go ahead and they still don't do the EIR, and you can win easily at the Superior Court level, depending on the county and judges and all that kind of stuff, but generally you win. So the burden, if you will, is reversed once a full impact report has been done. Wiser and more responsible developers, when there's a debate at all about whether to do a neg deck or mitigated neg deck or an EIR, they'll opt to do the EIR because then they are better protected in the event of litigation. So, because what happens is, rather than having this light trigger, is there substantial evidence in support of a fair argument, it becomes, when they're defending the EIR in court, a matter of largely substantial evidence. They say, well, you know, you submitted a letter saying X, Y, and Z. They have a letter over here which says no, 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 no. Okay. That letter, if it's from an expert or somebody who's qualified, constitutes substantial evidence. And the court will say, well, whether or not I agree with what the citizen said, the developer's consultant says this, this, and this is substantial evidence, and that's all you need. You're home free, developer. Okay? So be aware of the bigger sort of tactical issues associated with a neg deck and an EIR. If the developer is really smart, it's a really big project, they're not, you know, stupidly in a hurry for whatever set of reasons, it's often in their interest to do the EIR because they're better off in terms of defending the lawsuit. Now, substantial evidence is not the only basis for challenging an EIR, and this is something that's important to keep in mind in terms of your comments, because there are procedural requirements associated with the process. And if they don't follow them, then the legal theory is you violated CEQA because you failed to proceed in a manner required by law. One of the classics in that area is that somebody brings up a whole bunch of issues. Well, no, let me restate that. Let's say somebody comes in and says, okay, so I got 3 main issues that I'm concerned about. And I'll take an example from this Esperanza Hills project. One of the things that happened after an EIR had been done was that Southern California Edison had announced a new policy to where, in the event of a serious wildfire risk, they were going to shut off electricity to certain areas. Well, this project next to Chino Hill State Park, it's not only in a high-risk wildfire area, it's burned many times and so on. And in 2008, during the Freeway Complex fire, there wasn't enough water to fight the fire. And so when they went through the EIR on this project, they said, oh, well, we're going to have all these safeguards in terms of gravity-fed tanks, and the water district keeps water in there enough to fight the fires at a certain level, and so on and so forth. So all this was assumed in terms of the EIR analysis. Well, what happened was, within the last year, as all this litigation's been going on, SCE came in and said, okay, you know, we're going to cut off electricity in these areas generally, and that means they can't pump the water into the tanks. And then there was research done by some of the citizens that established that the notion that the tanks were being kept 3/4 full was not true. In other words, the firefighting people had said, well, we need the tanks 3/4 full to be able to fight a fire in this area. And everybody said, okay, well, and that's what they do. Well, in fact, they don't. So that's new information, new facts that require further additional studies from our standpoint. Now, the county and the developer are saying, no, 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 that's all insignificant, right? But, you know, if you don't have water, that's kind of fundamental, you know, to this whole issue of firefighting and so on and so forth. So you have the ability to put forward that, and you should put forward that kind of new information to require additional study and consideration. But the developer will fight, and in this case they are fighting us over that. But to tie it back to failure to proceed in a manner required by law, if you bring to the attention of the lead agency this information, depending on the procedural context of the project, they have an obligation to respond to it. And if they don't, that's a failure to proceed in a manner required by law. They have an obligation to provide a reasoned response. They don't have to write a doctoral dissertation on it, but they need to give a reasoned response to it. In this particular case, they basically did not even respond to the issue of the new Edison policy in terms of the approval of the project and the new revised EIR. And that's a failure to proceed in a manner required by law. So that's something where you can the judge can make that decision, and it doesn't have to be burdened with the substantial evidence deal, where it's like the judge can look at it and say, this is really stupid, but there's substantial evidence over here supporting it, so I can't do anything about it. You know, boom, developer wins. So is your hand up?
Yes, my hand is up.
Go ahead.
So is it true that if the EIR is contrary to the general plan, because that's what I'm thinking of the Banning Ranch, am I right? was the Banning Ranch thing, was it an EIR win against Banning
In the
Ranch?
end, it wasn't the EIR win in the lower courts, it was a policy win. So
Okay.
they didn't, the city did not follow their own policy on getting the proper agencies involved in delineating the environment out there.
But in the
Then
end,
we
it was-
lost in the appeal, and then it went up to the Supreme Court, and we won on the EIR corrections then.
Yeah, so if there's a general plan policy that for whatever reason, and I'm trying to think get my mind around how you would have an EIR that doesn't mesh with the general plan, then the general plan trumps that. And so am I right or am I?
Is that procedural? Is that
Well, you
what's-
can't, one simpler answer about all that is you can't build a project that's inconsistent with the general plan, whether the EIR says or not. And the problem with the general plans is that they're often, they're too general, okay? And which is why when you're amending a general plan, you don't want may or should or will strive, you want shall.
Yeah.
I sat on a general plan committee for the city of Encinitas in the 80s after we were newly incorporated, 2 years developing a general plan and looking at every property. And we fought with the consultants for the city, some of us on the committee, every time because they wanted, you need to maintain flexibility. So the language needs to be may or will strive, will do your best efforts, whatever. It means nothing. You need shall, and it needs to be specific, and that's how you protect your community and your resources. So, okay, so on this packet, let me refer you to past the table of contents, and I want to go to a map right here. If you can see, you can get that. So that's the project footprint. This is the project footprint. And you recall that I talked about how you have to discuss the surrounding environment. And believe it or not, one of the things that they did when they did this CIR originally in this case, they basically forgot about several thousand acres to the east that were part of Chino Hill State Park that were immediately adjacent to the project site. And so one of the issues in public comment before it was approved and then in litigation afterwards was that they did not properly consider impacts on that portion of Chino Hill State Park to the east. And by the way, to the extent you ladies and gentlemen were involved in Banning Ranch and you won that case, which is great, you've helped us a lot on this case and others with the 3rd Division, 4th District in Orange County because they got their wrists slapped and they're paying more attention to the law. Previously, it was believed that you literally couldn't win a CEQA case in Orange County. And because of very conservative judges and courts of appeal and so on and so forth. So anyway, it's amazing what happens when the Supreme Court actually steps in and says, no, you're not doing this right. And thank you for your help on this other stuff. So in any event, this kind of map, most of you have seen EIRs and all that, so it's not news to you, but this is the kind of illustrative map that you want to see with respect to a project. But guess what? You see that white area there to the left of the square?
To the right.
Excuse me?
Right, to the right of
To the right of the square. Yes, thank you, Melanie. Yeah. So that's Chino Hill State Park also. And so this map, right?
Yes.
Yes. So this map is incorrect.
It's incorrect.
It's incorrect. Okay, so this is what was in the original EIR. And when we pointed it out, the county and the developer and the consultants all just said, no big deal, it really hasn't impacted our analysis and so on and so forth. So, yeah.
So easy to fix.
That's right, exactly. And they basically refused. They refused to do it, and the project was approved, and that was one of the grounds. We went up to the 3rd Division of the 4th District, and they agreed with us. Well, thank God they agreed with us. Said, okay, you got to go back and you got to do it right. And without getting too much into this case, they went back to so-called correct it, and they really did an inadequate job. And now that's going to be, that's a continuing subject with respect to our litigation complex that we built around the project. So let's see here. Let's flip a few pages in to this map here, I think it's 3 pages from what you were just looking at. So this is, I wanted to point this out to you because it talks about other projects in the area, and this gets to this issue of cumulative impacts with respect to the project. So what you see there is a area denoted Cielo Vista. Above that, Bridal Hills. Above that, Yorba Linda Land LLC. And so these are potential, and in the case of Cielo Vista now, projects that are going to get built. And so all of this needs to be considered, if you will, together in terms of the cumulative impacts on the park, on the existing neighborhoods, and so on, and perhaps not just those projects, but projects within a 2 or 3 mile or 4 mile radius may be material to what's going on in terms of the synergy of the impacts and so on. So you always want to be very much aware, and this gets back to the watch list and the early warning and all that. You want to be on top of what's being considered. And there's nothing wrong. In fact, I've told clients before, you should have somebody, and maybe you guys are doing something like this, you walk into the city planning department, once a month and say, hey, so what's new? Anybody been, asking about this property or that property or whatever? And you should have, if there's properties that you're concerned about in particular in your community, they should be on your watch list, whether or not there's a pending application. And you need to be following up on that property on a regular basis, because you never know what's going to happen. And we've had property.
Will they tell us, or would they consider that kind of confidential information?
Well, it depends on your relationship. And let me comment on this too. This is really important, and I can tell this would be everybody's natural disposition. But you want to become best friends with the people in the planning department. And you don't ever want to get crosswise with a planner. Even if you think they're full of SHIT, you need to be nice to them. And, I learned that lesson the hard way. I was on a planning board in Encinitas before the politics changed for the new city. And when the developers and some of the people would attack the staff, boy, we circled the wagons, and we would protect them. And I was kind of surprised. It was kind of a primal reaction that I had to it. But the fact of the matter is the staff can be your best friends in terms of information. They can be friends in terms of lobbying internally. You've always been to be nice and respectful to them. Just like, unfortunately, you need to be nice and respectful to some of the jerk politicians that are sitting up there on the dais making bad decisions.
I tell all of them I hate them.
That's right. No, you can't do that, because they may become your best friend next year or 10 years from now. There is no area where don't burn your bridges that is more applicable than in this area, as tough as it is. But you're in this for the long term. And I see we're out of time. I will hang around for a bit for questions and stuff and all. But, you're in this for the long haul. And you're in this for the benefit of your community and your kids and your grandkids and all that. And I applaud you. You're the heart and soul of the future of California. And, you're doing good things, and please keep it up, and thank you very much for your time today.
Kevin, can you just give a quick summary of the mitigated neg deck and what happened with that
Yes.
without going through it?
Yes, thank you very much. So we had given you a packet. There are 2 additional packets, one dealing with a project in San Marcos called San Marcos Highlands. And this is an example of an environmental initial study. And this was a project down there where they tried forever to do an MND, and we kept pounding on them, and finally they said, okay, we'll do an EIR. The other one is a packet, and this should be of some interest to you. This regards a real case that we have litigated and settled involving Molten Nigel Water District. They were looking to expand their operations center, and they were insistent that they would only do an MND. And it's an example of them, for in my opinion, very obvious reasons. They didn't want to do an EIR because they didn't want to do with cumulative impacts, growth inducement, and they didn't want to deal with contamination. And they were trying to short circuit the whole process by going with a neg deck. And it turned out that one of the things that we discovered through experts and all that was their site was heavily contaminated. And they were, again, just trying to sweep that under the rug. But they went ahead and stayed with the neg deck. Even though we told them they needed to do an EIR, we sued them, and they basically said, okay, I guess, you know, you got us. Like they called our bluff. So, but anyway, it's an interesting read. Involves homes up on hills, sort of in a bowl shape around this operation center with major noise issues and so on and so forth. And it was an interesting case. So, is that enough?
Yep.
Thank you.
Thank you. Well, thank you again for expertise, 30 years in CEQA and land use law?
My pleasure.
Clearly it shows there's some experience there. I just want to point out this one map that he ended on. The areas in green, dark green, are what they missed in terms of the boundaries of Chino Hills State Park. So now you know there were a couple of examples of what were in the EIR that were wrong, and then this map was created to show them where the park actually was. Because residents can actually provide comments on an EIR, so can agencies, so can other cities and attorneys. And so we've included on this particular project an example from an agency. So Chino Hills State Park provided a comment letter. We have one from Kevin. We have one from a nonprofit, Friends of Harbors, Beaches and Parks, and then one from me as a resident who ended up going through some of the contents and providing, it's a long story, but the evacuation routes that Kevin had been referencing.
What page is that?
Oh, so this is after the big map. So it's following those state parks, Kevin's letter, Friends of Harbors, Beaches and Parks, and then mine. Back to
Melanie's
the policy.
letter, by the way, is the best one. Point that out.
Lies, all lies. But because we did our homework, we had talked about policies. I think Susan brought it up with the general plan. I ended up doing quite a few Public Record Act requests for the city of Yorba Linda, and so I didn't include any of the attachments to it, but you can see what's referenced in here from track maps, from the general plan, from the municipal code, etc., and pointing out where the problems were. And the residents, because I know SPON has been involved in this, doing all sorts of referenda on a project, right? So we had confronted the city saying, if you allow a road through this land, which was designated parkland, then we'll referenda it. And it ended up that the developer had written an agreement with the city that required eminent domain, which in Yorba Linda would not be okay, and in most communities aren't okay, but there was an existing policy on the books, Measure BB, that said you can't use eminent domain for the benefit of a private entity. And so we pointed that out, and they followed that law, and we didn't need to do a referendum. So that was fantastic. So there's all sorts of shifts that happen in a project because you've done your homework. So it's important to understand the context related to a specific site, the policies that apply to it. You are your own experts. I mean, my mom, I think most of you know, created Chino Hills State Park, and so when she sees a map that's missing 1,262 acres right next to the project, she was a resident expert. So that was a really easy find, and if you fundamentally don't have a project description right, what else don't you have right? So it makes you question the integrity and credibility of the entire document. So congratulations to Kevin, we just won in court yesterday on this. So we've got 7 lawsuits that have been filed, and the 3 that have been decided, we've won. So, but we ultimately, because of fires like the Camp Fire and the Woolsey Fire, where people are dying in their cars, we know that sites that have burned multiple times have a risk of burning again in the future, higher than in other areas that haven't burned. And just because you put people in houses there and change the grading and put roads in, doesn't change the fact that it still burns. And so residents came up with viable solutions. I think that's kind of another thing with kind of banning ranch, knowing what you want to do. What's your end goal? The residents wanted to stop the project. The supervisors weren't listening to that. So we came up with like 15 different things, and we said, if you do these 15 things, we won't oppose the project. They approved it again. So then we came down to just 2 things: reduce the density and require a second access, and they still wouldn't do it. And so we keep giving options, trying to be reasonable, and the answer is no. We've offered to buy the property. All sorts of things come up. So in this process, know what your end goal is. That's probably one of the biggest pieces of advice I have for any community group that uses an EIR and CEQA for defending your community. So CEQA is a complex law. There's a lot that goes into it, and you have knowledge that can be applied to comment letters. When you go to a planning commission or a city council and you're actually serious, make sure you've hired an attorney, because they know that you're serious, as Kevin mentioned, if you have something on letterhead that says it's from a law firm. If you don't, then it's all just talk at that point. That's not to say you can't be successful. I know it's happened when a resident has done it all on their own, but you have a higher likelihood of success if you've hired an expert. So we've hired experts in Yorba Linda on traffic, on hazardous waste, fire, evacuation, water, all sorts of things to put information into that record. So thank you, Kevin. And oh, yes, go ahead, we'll clap. So this ultimately concludes, do you want me to do the wrap-up? Okay, this ultimately includes the series of workshops that SPON is offering, and Dorothy's going to chat momentarily about the general plan and what's happening there. But as I referenced early on, you've been trained now. You have information on what to do, and SPON will serve as a resource, keep you informed, etc. But Kevin also has resources. If you want to buy a copy of the actual CEQA guide, this isn't it. I don't know why I just held it up. But if you want a copy, it's $35, right?
Right, and the money goes to PCL.
To the Planning and Conservation League. They do community workshops. They have this guide available to you that breaks down the pieces of the law. And so we have a handful that we can sell today, or I'm in contact with their executive director and can get them down here if we need more. Question in the back.
You mentioned hiring experts. Where did your money come from to do that?
Oh my gosh, if I could only tell you the number of fundraisers that we have had. It completely depends on your community. We have had angel donors that offer challenge grants. We've done fundraisers at restaurants. We've done garage sales. We've done
that's good.
everything under the sun. Go ahead, David.
But, you know, by the way,
I want to respond to that also. I'm the treasurer for SPON, and I guarantee you I've written a lot of very big checks to attorneys over the last many years. One of them happens to be a firm that's expert in CEQA. And so SPON is writing checks and a lot of, I wrote one this morning. So to Karsten's.
Right, and that firm also sits on the PCL board.
And
So
just so you know, you do have an organization that is doing just what they're talking about right here in town.
Right.
I was just going to say also, the experts can be hired sometimes for numbers that are not shocking. So like you can get often I'll get an expert who will do a letter for me for like 4 hours at a time at $200 an hour. So you can have, at least initially, you can have somebody take a look at it and get, something at a reasonable rate. That's significant, but it's not $10,000 or
That's
or
what
whatever.
SPON has so often done that, where we wanted SPON to be represented by an attorney. So like Karsten's would often do and it's not that much, and it's really worth the punch.
That's a great firm, by the way. They're part of our
Yes.
advisory group that's looking at the statewide reform.
Yes.
Michelle Black on Speed Black.
Yes, exactly. All right, so if you have questions, let us know. Kevin said he'll be around. Dorothy's going to chat about kind of next